but it has similarities. Long back when I went to, as I was saying, in Colombia, this was 1969-70. Many of you were not born at that time. That time after the civil rights, President Lyndon Johnson's programs of affirmative action, you had liberal funding for setting up legal aid clinics in law schools. Not all American law schools bought it because the American scholars, law teachers at that time believed being a clinical teacher is not scholarship. You are not writing and publishing. So clinical teachers were considered to be second-rate teachers. Their status in the faculty was not that equal, though there was anyway in 69-70 there was clinical program just started in Columbia Law School, Harvard Law School, some 3-4 law schools here and there. I had the benefit of observing it. There was a lot of Ford Foundation money flowing into these programs and lot of experimentation was looking. And I believe that some of the American law teachers came to India to look at how disputes are resolved outside the courts in India. Mark Gallanter is one such person. And they have written about it. And we found, well, we should also be using some of these techniques whereby disputes are resolved outside the courts as part of legal education. These are socially relevant legal education. The students will learn a great deal as to what goes into the dispute resolution process, what goes into judging, what goes into appreciation of evidence, what goes into the cultural differences when somebody gives testimony in a court, how to appreciate it. So many nuances of the legal and judicial processes came to be appreciated when we started looking at dispute resolution outside adjudication. We borrowed all of them, simulated in the court, in the law school, and made it into clinical programs. So much so, in the 1990s, when we started doing it in a big way, I think you were there at the Florida Law Teachers Conference, in that gauge idea was conceived. I gave a presentation in the American Law Teachers Conference in Florida on socially relevant legal education, where the main thesis was some of these experiments whereby many qualities, skills, ethics, which a future lawyer ought to have, can be taught by methods which were not known at that time. This enthused many American law teachers, many Canadian, Australian teachers. Some of us got together, and in 1999, in my hometown of Trivandrum, we had a conference and we decided to create a body of clinical teachers who are looking at examples around the world. And this organization is today known as the Global Alliance for Justice Education. It was in that conference we decided that we must move from law education to justice education. It is not the bare letter of the law that we are educating the students. We are educating the students about the complex processes of administering justice in a society which is highly competitive, exploitative, unequal, so many things. And the purpose of law education should not be missed. That is why in the Carnegie report on American legal education a few years ago, a serious indictment of the Langdalian method of case analysis, making a law student to think like a lawyer, act like a lawyer. Carnegie report said, this method which you are practicing, they are making robots of the lawyer, as if they have no concern with the idea of justice. So in a case analysis classroom 20 years ago in Columbia or Yale, if a student were asked about some sensitive issues relating to justice in a case, the professor might say, no, that is not your concern, you go to another school, not the law school. Here you have to develop those skills of winning a point over your opponent, that adversarial style, and you have to limit it. The The questions about justice was non-lawyer-like. I'm exaggerating it, but that's the point. That is the essence of the Carnegie report, wherein the American law schools are now attempting to see how you can create an ethical lawyer, a human lawyer, a social sensitive lawyer in this method. But that does not mean the analytical skill, which is the primary skill of a lawyer, can be abandoned. It has to be there, but it has to be moderated with other clinical education. So slowly, steadily we have now, though it cannot be said to be a part of it. I'll give you some statistics. In 1950, we had about 50 law colleges in India, law schools if you like. 1950, that means around 60 years ago. Today we have 960 law schools. Mind-boggling. 960 law schools. I mean, all good, bad, indifferent, everything is included here. In my calculation, out of them, only about 150 to 200 deserve to be called a law school. But others are also producing LLBs. What do you do? How do they produce? You have to discover. Now, about 200,000 students are there in the law schools. 200,000 law students. It varies. Sometimes it goes up to 300,000. On an average, I understand about 60 to 65,000 law graduates are passing out of these 900 and odd law schools. Now these 60,000, luckily all of them do not enroll at the bar. The lawyers enrolled on an average every year varies between 30 to 40,000. We have today overcome American bar. At one time the American bar was the largest. But today India has a little over 1.1 million lawyers, increasing at the rate of about 20 to 25 every year. So you can imagine the size of the Indian legal profession. Too huge, perhaps. But luckily, many of them, when they get an employment in government or corporate sector, will run away from practice. So the actual practitioners that are there, appearing in the court, taking the matters on behalf of their clients, may be perhaps half of this number, 1.1 million. This is a guess, but an intelligent guess you may say. They are now being mooted as the legal education must. You know, the legal education was not considered a professional education at all 30-40 years ago. But today, after economic liberalization in India, which happened in 1991, law has suddenly become an option for bright, talented students coming out of colleges. Otherwise, engineering, medicine, architecture, all these technical courses were attracting the best of students that were available from the school. But today, law has become, because opportunities are increasing. And so very bright students who would have otherwise gone to a medical school or an engineering school are today applying to the law school. So the legal profession is now looking up. The legal profession is trying to negotiate with countries for trade in legal services under the WTO regime. When foreign direct investment come into the country, naturally the lawyers are sought after, and there are more and more lawyers in this country who do not go for litigation, but do what is known in America as transaction lawyers, negotiation, documentation, contract, etc., etc. This phenomenon was unknown in India 20 years ago. Every lawyer was considered to be a lawyer in court. So the popular mind, even today, a lawyer is a man with a black gown jumping from court to court, conducting, cross-examining this and that. But that is changing, particularly after economic liberalization. So much about legal education. Some questions on that? Is there, yes, ma'am.
The first thing I want to ask is, in the law school, the student will learn every kind of law, every subject, or will divide into this specialize?
Yeah, we broadly divide. We have, let us say that the Bar Council of India has recommended about 29 subjects as part of the 3-year LLB program. Now, out of these 29, much of which, of course, the bread and butter laws, the contract, tort, constitution, all that, family law, all that will come. And then there will be 1/3 of these 29 will be optional courses, where the students can choose any specialized seminar courses or other courses. And in national law schools, the option will be too many. Almost 50% will be optional and 50% the core courses. This is how the curriculum is expanding. Because unlike the American law schools, in the national law schools, 5-year program, we teach economics to law students, integrated with contract law, tax law, trade law, etc. Or political science, integrated with constitutional law, public law. Or sociology, integrated with family law, criminal law, labor law. So new experiments in legal education, in idea being that you must study law in social context, in social reality. So you must give them the essential techniques to understand social reality, to be able to be critical consumers of social science knowledge, things like that, if you want to use law as a policy instrument. So that way it is expanding. Yes.
Sir, you said that there is some kind of the liberalization was affected for the Indian legal educations after of 1991. Is that related also for the opening of the Indian economic?
That is it. That's it. And actually the liberalization is in relation to economy. When the economy liberalized, our laws, which were at that time mostly modeled on the socialist system, got changed into the capitalist model. So naturally the law school took the cue and started teaching about securities law, insolvency law, this law, that law, capital market, so many other things with, which otherwise was not in our law curriculum.
Yeah. Also there is some kind of the Indian law schools like ILS or something like that, that it has accredited for the studying of the bachelor degree of law LLB for 3 years only. There is no 5 years. So what is that?
That is equal. That's all right. The Bar Council recognizes whether you come after a 3-year LLB, which is after a basic degree, or you come up with a 5-year LLB, you are both equal to become a lawyer. Yeah. So it recognizes 2 streams of legal education.
3 years or 5 years?
Both. So there are some law colleges which teach only a 3-year program. You have limited faculty, you don't want to introduce clinical courses, this, that, which is expensive. Some colleges which are like national law schools, which have only 5-year program. And some have both, depending upon availability of students.
And what do you think, sir, about the private law schools in India?
There is out of 960, 700 are private law schools.
Or do you think that it has the same, what we can say, visions of the national law schools?
No, not at all. Not at all. Exceptions apart, the bulk of them are for making some money. And they are doing some other commerce college or science college, and in the evening it will be converted as a law college. And then some advocates from neighboring courts will come and lecture and complete examination, and so I am generalizing, but there are many such law colleges which are not law colleges. They are giving basic legal literacy, but not the necessary knowledge and skills to become a lawyer. So therefore, that is why people drop out. After becoming lawyers, they find they are not able, they have not the equipment to be able to survive in a practice. So they go for some government jobs or other things.
Because some of these private law schools are listed as one of the strongest law schools in all India.
No, there are some, as you mentioned, the ILS is one of the strongest law school. It's a private law school.
ILS, Amity.
Yes, Amity, yes, the Symbiosis. So many are there which are private. In US also is a private, Salgokar Law College in Goa. So some of the law colleges where the person who has started it invested money. You know, one of our best law schools today, or best you can't say, but coming up law school is one which is very close by is a global law school. It's a private one by an industrialist, the Jindal Global Law School. Okay,
Could you comment on the requirement of clinical education?
For the enrollment as a lawyer? It is not expected. Some bar council says you must have some practical training, by which they said that you must have some moot courts, you must visit the court, understand the proceedings there, something very elementary, which does not really enable the student to assimilate the skills of advocacy. So, you cannot say that the bar council prescribed curriculum has a clinical component in it in the manner in which we understand clinical education. But teachers on their own have adopted by introducing a family law clinic or a criminal law clinic or a prison clinic or things like that, and introduce students to make it, but it's optional, not all students. And they don't get academic credit in many cases. So people who are interested may come, that's all. But it is not the case in national law, which is a residential one, where we are increasing the clinical activity more and more and absorbing students into one or other activity. Is excellent returns. I think, like what you have in Washington, that a totally clinical school, isn't it?
No,
Huh?
no, Antioch and
Like the Harvard, Howard.
Oh, Howard.
Howard.
Oh, I thought you meant the University of District of Columbia, which requires clinical.
Yes, that is.
It used to be called Antioch.
Yeah, right. Anyway, that I believe it is going to be more and more. Let me just briefly tell you in the remaining time on human rights in the Indian situation, which is your main thrust of your course. As I have already explained, we have 6 fundamental rights, though it is 6 only, each one a bundle of rights. For example, if you talk about right to freedom, there are 6 different right to freedom: right to speech and expression, right to peaceful assembly, right to choose any occupation, trade or business of your choice. So many like that are there incorporated. So if you look at and count all that, you will have perhaps more than 15, 16 rights guaranteed as fundamental rights. And by interpretation, some of the directive principles which were a mandate to the legislature to legislate and empower people, the court has transposed to the fundamental rights and started reading into it. But that doesn't take us far, because if you were to enforce it, you have to necessarily have legislation, because budgetary allocation will have to. Court cannot ask budgetary allocation to make right to education. So for a long time the court recognized right to education, which was part of the directive principle, not guaranteed right, but no implementation. But now the parliament has decided no, right to education is basic, without which no empowerment. Therefore they brought in a legislation, a constitutional amendment followed by a legislation. And now the central government has allocated a huge money for that. And then it becomes rather enforcement in the real sense of the term. Okay. We have the freedom of religion is a very interesting right in our constitution, as it is in yours. Yes, in American Constitution, even burning the national flag is part of
speech.
Perhaps imbued by that interpretation in the American Supreme Court, the Indian Supreme Court said that not singing the national anthem, if somebody claims as part of one's religion, it's a very interesting case, I must tell you about it. There is a group called Jehovah's Witnesses in the Christian religion, I suppose, perhaps not religion, I don't know what group is that, some denomination. And they don't recognize any one country or flag, as they don't recognize or worship or do anything. What happened in the state of Kerala, where I come from, the school board decided that the students should be given some patriotic, nationalistic spirit in the education. So in the morning the students should be assembled and the national anthem should be sung before the classes start. So a circular was issued by the government that this is mandatory for every school child. So the principal teachers will also join, and they found a group of children not singing, despite the fact that they have to sing. This is a government order, it's part of the law, and if you don't sing, you will be removed from the school. They did not still. And when they were asked, they said, our parents said, you should not sing it, it is against your religion. So what the hell is your religion? How come this could be like that? So the school removed those children as a violation of this law. These children came to the court, right up to the Supreme Court. And the Supreme Court interpreted, if it is part of your religion, what you believe to be your religion, even though it's a, and if they don't disturb others from singing that religion, it is their religious freedom. And they were asked to be readmitted to the school. So the religious freedom is interpreted, and we have the freedom to convert people into your religion. Freedom to preach, practice and propagate. This is what the freedom of religion talks about. Freedom of religion includes freedom to practice, freedom to preach, which includes conversion, but not forcible conversion, and freedom to propagate your religion. So it is a very broad concept of religion. It cannot be otherwise. Though there are conflicts, when you convert from Hindus to Muslims or Hindus to Christians, you can expect a lot of ill feeling in the community, in the region, some of which have erupted into conflicts. So you can only contain it and treat it as a law and order, but it is a constitutional right if you persuade other people belonging to your religion to convert their religion into one's religion. Some of the states are trying to legislate, saying that forcible conversion, not all conversion, is bad and will not be allowed. But what is forcible? I will give you admission or education free. You come to Christianity. Or your family will be treated in this missionary hospital free if your family changes your religion. So many conversions are taking place like this. Is it forcible conversion? Is it unjust inducement? You can ask questions. It depends on the facts, etc., but it is a big constitutional issue in this multi-religious country. I don't want to go into the labor rights or environmental rights, which Prasad will be. How do the human rights get enforced? Interestingly, one of the guaranteed fundamental right in the Constitution is the right to enforcement. What is called the constitutional right to constitutional remedies. Ordinarily, when a right is violated, you go to a civil court or a criminal court for its enforcement. Whereas a fundamental right, you straight away go to the Supreme Court or the High Court, the highest court of the land, for a writ or an order which every executive, central, federal, state, local, whatever, will have to implement. So this constitutional remedy and empowering the court issued orders, writs of the nature of habeas corpus, quo warranto, certiorari, prohibition, you know the various writs, which will enable a quicker enforcement. Sometimes within a day you get the remedy. Habeas corpus is such an effective writ. If somebody is unlawfully detained, you file a petition and it doesn't have too much cost. You can the court will immediately ask the executive to produce the body of the detainee and explain under what law have you detained. And if the court is not satisfied, right in the court the person is released. So such quick enforcement of constitutional rights are provided for in Article 32, which is itself a constitutional right, right to constitutional remedies. Otherwise, of course, enforcement will depend the legislative procedure and the depends the state executive finally implementing. Judicial review is a powerful instrument. We have to close now?
7 o'clock is the live telecast there, sir. Same inauguration.
Oh, is it?
Yes,
Oh, I
sir.
see. Okay.
And where you will be speaking for 10 minutes.
Oh. So, can we close it in another 10 minutes?
Maybe, sir.
Huh? Okay. All right. Being the first day of your program, there are some ceremonies.
Maybe 5 minutes, sir.
Yeah.
Maybe 5 minutes, 10 minutes to go there.
Oh, to go to the across. All right. Okay. All right. I leave the constitution tomorrow, both Martin and Prasad will be doing. I just want to sort of conclude by, of late is a problem now. America also, after the event in the World Trade Center, terrorism and how it has impacted in our legal and constitutional systems. Whenever such things happen, which are of a serious challenge to rule of law and established systems of government, the state is duty bound to resist it by appropriate techniques. So what has happened in America, India and some other countries affected by terrorism is that we have amended the law and procedure, giving more and more powers to the executive, police powers, prolonged detention, shifting the burden of proof, denying some of the rights which ordinarily is guaranteed in the criminal procedure as part of human rights. So you have modifications that has happened, and the police got empowered with powers of search, seizure, interrogation, detention, custody, several of these things, much longer than or much greater than what is ordinarily permissible under the established criminal jurisprudence in the light of the constitutional human rights. Well, to what extent you can justify it in specific cases? Should the state be so empowered? If so, can the canons of criminal jurisprudence can be diluted? To what extent? These are questions which are to be debated, which is evolving jurisprudence. When you look at international human rights, you have to necessarily appreciate it in the context of the terrorism that many countries are facing today. And there is no other way excepting empowering the state and seeing that the state do not cross the boundaries. But strictly speaking, in normal circumstances, you find that this is constitutionally objectionable. So this has happened in India. It's a question which is yet being debated. The Unlawful Activities Amendment Act has made several inroads in criminal jurisprudence on presumption of innocence, burden of proof, appreciation of evidence, things like that, and the period of detention, the interrogation powers, the use of methods which are objectionable. I don't know how far in your brain mapping, lie detector, so many tests which are yet not scientifically proved to be not invasive, but are being adopted in the course of detection and proof, which are constitutionally challengeable. And this is a grey area of human rights jurisprudence which is affecting the world, the liberal democracies, because of the emergence of this terrorism, violence and things. Very good area which I am sure that in the course of your discussion you will have occasion to discuss. Elumalai has come. I suppose that you are introduced to all of them already?
Yes, sir.
Okay. So the director has disappeared to Bombay and reappeared now. So therefore the inauguration will take place. I suppose I will close if I get some time. Maybe I hope to join the class of Martin and Prasad.